Hello, this is Professor Tom Herskowitz, and this video is about Employment Laws, Chapter 21. Should be fairly quick. Just hit some of the highlights of some of the laws that affect us as managers in our companies. The Fair Labor Standards Act, this is the Minimum Wage Act. It sets the requirement for minimum wage, and it also sets the definition of overtime, the amount of overtime, record keeping, who gets paid on an hourly basis and who gets paid on a salary basis. It requires overtime at 1.5 times the regular pay rate. Workers in executive or administrative positions are exempted. This is a big deal as to whether you get paid for the 60 hours you work as a manager or whether it is part of the salary and included in it. The case of Sandifer v. U.S. Steel Corp., collective action for time that was spent on actually donning and doffing their clothes. Doesn't sound like much of a big deal, and it's probably only a few dollars a week to the employees, but if you have a large corporation, you have 1,000 employees, and this is a class action, it can be a lot of money. The WARN Act, the Worker Adjustment and Retraining Notification, if a plant with over 100 employees is going to close, they have to give at least 60 days prior notice to the closing and the layoff. This is something most of you are familiar with, the Family and Medical Leave Act, FMLA. It provides eligible employees with 12 weeks of unpaid leave following the birth and care of a new child, adoption, an immediate family member with a serious health condition, or employee is unable to work with a serious health condition. So that means that the person may not get paid, but they do have their job protected. And this is for any employers that have 50 or more employees, and the employee must have worked for at least 12 months for the employer. You can't get hired and then the next month take off 12 weeks. So the employer is required to keep the job available. FMLA does not permit time off for travel overseas for adoption of a child. True or false? It's false. It does. Of course it does. Okay. USERRA protects the rights of individuals on from military duty. Don't fire somebody because they have to go and do their military time. Important one, OSHA, Occupational Safety and Health Administration. This impacts all of our lives. It provides standards to furnish workplaces free of recognized hazards, and a workplace also includes public spaces where employees are working as well. So employees can request an inspection if they think there's unsafe conditions. They can file a complaint if they're subject to retaliation or discrimination by their employers. We talked about that on the previous slide. One of the retaliation claims would be that they had reported an unsafe working condition. Family protected, the Obamacare. I think a lot of you have seen a lot of this in the newspapers. Has a lot of news going on about it. It's something you need to be aware of, and as it continues to roll out, make sure you're very familiar with the nuances of the requirements of the Obamacare Act. Limitations on employment at will. Now this is important because Oklahoma is a employment at will state. State can either be a employment at will or can be a union requirement. Employers can discharge employees without cause at any time at an employment at will doctrine. But an employer may not discharge an employee for the wrong reason. So if somebody is fired because of retaliation, making a legal claim of discrimination, OSHA, anything like that, then you cannot fire them. Labor Management Relations Act prohibits employers from discharging employees for union activities. Federal laws limit employees' right to terminate employers' rights to employ and to terminate employees. So yes, you can fire somebody because of economic cutback. You can fire them because you just want to get somebody else, but it has to be for the right reason. And remember that after they're fired, people are looking at it as Monday morning quarterbacking, and so you better make sure that you've crossed your T's and dotted your I's if you're going to fire somebody, especially if they've been causing some problems at the company for you. Workers' privacy, the Electronic Communications Privacy Act. You can't be forced to have a polygraph before you get hired. I've never even had that come up as an issue. I don't know why it's such a big deal. Some states have limitations on drug testing. I guess that's being politically correct. It would seem to me that if a person is taking drugs and you don't want them to be working for you, you should be able to check, but some states do limit that. Public employees are protected from drug testing by the Fourth Amendment, the right to privacy, as I say in some of these states. Workers' comp, this protects employees and their families from risks of accidental death. What was happening is that the employees would be injured and they would then not be able to sue because there was comparative negligence or contributory negligence. They had some part of it, assumption of the risk, things that we talked about when we studied torts. But so the workers' comp came by with a strict liability. It said if a person was injured in the course of the employment, then they can collect the medical costs or the costs of that injury. It's strict liability for the employers. And it provides cash payments for loss of income and medical benefits as well as the injuries. The test for determining compensation was the injury accidental. Did the injury arise out of and in the course of employment? And remember, you've got your coming and going rules. You have all sorts of things that look at whether or not a person was actually working at work. The exclusive remedy rule, employees' sole remedy for workplace injury shall be workers' compensation. So employers may not raise defenses against the employee's action. That protects the employees. But likewise, employees cannot seek compensatory or punitive damages against the company for injuries. This was kind of a trade-off. It was the employees did not have to fight to get the medical payments and the loss of wages, and the companies were not at risk for compensatory or punitive damages for the work environment. There can be other laws, other violations for that, but not by an individual. This is the employment eligibility verification, I-9. Your HR departments will know about that and what's required for being able to qualify for that. So how do you avoid employee lawsuits? Well, one of the most important things is adequate documentation offers the best protection. Create a paper fortress. It consists of job descriptions. Let people know what they're supposed to be doing. Don't tell them that they didn't do a good job when you're firing them if you never told them what was expected. Personnel manuals, employee files. You need to have annual reviews and make sure those reviews accurately reflect the performance. You cannot have somebody with stellar performances and then all of a sudden fire them because they're going to go back and say that there was retaliation for something because look at my reviews. Nothing was ever said that needed correction or improvement. Record of unsatisfactory work performance provides defense against lawsuits related to denial of promotion or discharge. Written warnings and letter of explanation must be preserved and put into the personnel file. There tends to be a kind of a bias against doing that. But if you don't do it, then you may end up having all sorts of legal problems. Okay, that's all for Chapter 21. Thank you very much.